Good evening, everybody, and welcome to USSAAC's webinar series. Tonight's presentation by Lou Golinker addresses an emerging issue, and that is changes to New York Medicaid speech-generating device guidelines. It's an important topic, particularly if you're in New York, and I think it also will provide some hints and tips and perhaps a forecast of what might be coming to other states. Next slide. So ASHA CEUs are available for the live webcast. I did want to mention to you that as the content for this webinar was fleshed out, it became evident that there was more content than could be addressed in 60 minutes. Therefore, we do plan to be on the air for 90 minutes for those of you who are able to stay with us. We will understand if you have to bail after 60 minutes and that was all you planned for. Unfortunately, because this was a last-minute change, it is still only eligible for 0.1 CEs. As you know, USSAAC members are entitled to free CEUs as a member benefit. It's included. The participant form and instructions for CEs are on the website, and you do have a deadline by which you must submit the form to our Director of Education. Hopefully you know that all of USSAAC's webcasts are archived and available online. As we go through tonight's session, you may enter questions in the chat box. Please try to keep your questions generic rather than specific to a particular individual. We will answer as time permits. I do want to draw your attention to the fact that there are handouts for this webinar, and those are available to you through the webinar platform, and they'll also be available after the webinar as well. So next slide, please. As I mentioned, you'll receive a follow-up email with links to the CE form and an evaluation. We ask that you kindly complete the evaluation, which informs our planning and scheduling for the webinar series. Disclosure, as you saw on the first slide, Lou Golinker is the Director of Advocacy for USSAAC. We hope that you'll participate in other USSAAC webinars. Our next one, in conjunction with Emergency Preparedness Awareness Month, is September 19th. If funding is a topic of interest, and judging by the enrollment for this webinar it is, and if you are going to ATIA, you will be able to hear more from Lou and from our colleague Lisa Bardak at an ATIA pre-conference. So stay tuned for more information about that. We hope that you'll follow USSAAC on Facebook, because that is one of the ways in which we get the word out about important events. And we're also thrilled to be starting a series of funding tips thanks to Lou Golinker. So without further ado, let's hear from Lou about these changes and challenges with New York Medicaid. Lou?
Ladies and gentlemen, we appear possibly to have an audio issue. Just please bear with us a moment or two while we see about getting Lou's audio enabled. Sorry, ladies and gentlemen, we're experiencing a temporary audio difficulty. We are working on it. Please bear with us another moment or two. Thank you.
Okay, it says I'm connected. Am I connected?
Yes, you are. We hear you now. Thanks, Lou.
Okay. I'm very sorry for the delay, but it looks as if many more people have joined and hopefully not many people have left. So I'm going to start over and go through this presentation as we had originally planned. So thanks everybody for your patience. So this slide starts with the eligibility standard because this is the origin of the change in the guidelines. New York Medicaid had coverage standards for communication devices since 1991. I just lost the screen. Excuse me.
So, Lou, your screen is showing on the webinar. You just need to bring your PowerPoint slides up. That's all. There
Okay, so I'm back to being semi-competent at this. And the guidelines that were revised, the guidelines that had been issued were revised in 2012. And for some reason, the new version of those guidelines included 2 SGD eligibility standards, and they appear in the first 2 paragraphs of this slide. The first says basically that you have to show the ability to improve using the communication device. That will allow the member to improve their communication to a functional level not achievable without the ordered device. But the other said that purchase should not be pursued until the documentation, including trial results, demonstrates functional and proficient use of the device. The third paragraph is missing a digit in the date. It's October of 2016. At that time, the proficiency standard was replaced with the word competency. And these standards are very different. A client can improve a lot and get a great benefit from a speech device as compared to when the speech generating device wasn't available well before the client would be described as proficient. Basically, the standards measure different things. And here's an attempt to show this as a graphic. Improvement measures change from a baseline, or in simpler terms, how far you've come. Proficiency is a label given to a specific level of performance, which is where you end up. For proficiency, the baseline is really of no relevance. In 2016, Medicaid began to ignore the improvement standard and to deny speech-generating devices based on that proficiency claim, and then later on competency. They said clients had failed to demonstrate mastery, competency, or that they were not very good at the device use, all of those representing synonyms in Medicaid's view. In October 2016, Medicaid recipients in USSAAC challenged Medicaid's reliance on the proficiency standard in court. The new guidelines were written to settle the court action. They're going to become effective next week, August 1st, and they'll apply only to initial funding requests filed with Medicaid after August 1st. Any request that's now pending decision or any request now on appeal will be decided under the existing guidelines. Tonight, I'm going to offer you an introduction to the new guidelines, pointing out some of their more significant provisions, and where possible, going a little deeper to suggest how the speech pathologist can respond. The presentation basically goes through the guidelines that were attached to the handout, or that actually serve as a handout, page by page. So we'll do it in order rather than jumping around. So let's start where we began the presentation with the eligibility standard of the new guidelines. The new guidelines are a response to the challenge, and because they were written to settle the challenge, the standard has changed. Medicaid removed proficiency, competency, and their synonyms from the new guidelines, but left the improvement standard in it. It's stated as SGD coverage criterion number 1I on page 106 of the handout. speech pathologists can recommend and clients will be eligible for the SGD and access method that'll provide the most improvement in their communication functioning above the client's current baseline abilities and opportunities. That's what the new guidelines will allow. But the new guidelines also have an additional component, and it's based on the client's ability to use the recommended items. Like the existing guidelines, it's based on the trial, but in contrast to the existing guidelines, it isn't based on an arbitrary, undefined, and unattainable standard like proficiency or competency. Instead, Medicaid identified 6 what I call show-me criteria, abilities that Medicaid wants clients to be able to do at the time of a purchase request. They're stated in coverage criteria 1D as in David and 1G as in good. Whether they're good or not, we can talk about through the course of the evening. And that's at page 106 of the handout. After a trial, clients must be able to do all of the following to get approval of a funding request. They have to use the device to produce functional communication. They can't be fully dependent on prompting or assistance in producing the communication. They have to be able to produce multiple message types, communicate with multiple partners, communicate in multiple places, and produce all of this communication on multiple occasions, not just once or not just during one session of the trial. And they're stated, as I said, in coverage criteria 1D and 1G. If we try to, the next few slides will try to interpret what these show-me criteria are asking for. The first and the second reference functional communication, and the guidelines refer to functional communication repeatedly, but there's no definition. An important clarification, though, is offered for functions of communication, and that's at page 108 in the documentation requirement 4B and then Roman numeral 7. This phrase includes requesting, protesting, commenting, and describing, etc. These examples and others are commonly considered the purposes of or the reasons for communication. And we believe you should interpret functional communication and all its variations in the guidelines as synonyms for these phrases, and that the guidelines reference to message types also should be interpreted as a synonym of these phrases. Here's a graphic that was prepared by Anne-Marie Hamelin from the Mary Cariola School in Rochester that shows 11 common purposes or reasons for communication. And this slide is just an illustration. It's not a comprehensive list. So knowing what clients must communicate allows of the show-me criteria to fit together. As part of the SLP assessment, consider the range of message types and communication purposes that comprise functional communication. Identify the ones that the client can produce using the recommended SGD. And then to meet the next criterion of the show-me criteria, that the client can use the recommended SGDs to produce this on his or her own without assistance, and to do so consistently. In addition, look for the ones the client can produce on his or her own without assistance, but intermittently. Sometimes the client can do it without help. Sometimes the client will need help. The client's ability to produce functional communication in either of these ways, what we would call independently, or what we would say they need intermittent assistance, that will satisfy the show-me factor of not being fully dependent on prompting or assistance. Next, the task for the speech pathologist will be to write trial goals and organize the trial sessions so that the rest of the show-me abilities, multiple, will be documented. They use multiple and repeatedly throughout the various tasks. And we recommend that you follow a rule of 3 to 5. Write 3 to 5 goals, each focused on a different message type. Then give the client the opportunity to communicate with 3 to 5 partners in 3 to 5 places and on 3 to 5 occasions to meet the repetition requirement. A word about people. Some message types will require the client to respond to questions from partners. Questions can be viewed as prompting or assistance, but sometimes they're just questions. It may be necessary to prepare communication partners so that they provide clients with the opportunity to demonstrate the functional communication ability that's stated in their trial goals. So that's a SLP task in addition to just writing the goals. It's part of organizing the trial sessions. Now a word about places. Under the existing guidelines, SGDs must be useful in all typical communication settings. Medicaid sometimes claimed useful required actual use in all these settings. Speech pathologists said, on the other hand, that skills are transferable across settings, so useful can be satisfied with a single location trial. When Medicaid issued denials with trial locations as an issue, the decisions almost uniformly sided with the speech pathologist. As the new guidelines were being written, Medicaid at first proposed an actual use standard, but compromised to say that trials can be at one site, such as a school or at home, but speech pathologists must report device use in multiple places within the site. So, for example, at school, show use in the classroom as well as elsewhere in the building, such as in the cafeteria, the gym, the art room, the music room, or in the playground. If you're having a trial at home, show use in the kitchen, the family room, the yard, or the kid's bedroom. Now a word about goal writing. Whoops. In addition to everything else that's just happened, the lights in the office that I'm sitting in just went off. So now I'm as much in the dark as you are. All right, they went back on. Trials provide an opportunity to observe the client's motivation to communicate, understanding of the device, ability to use the device, and the ability to benefit from the device's use. These show me criteria are no more than specific device use examples. Also, trials are not a time when new skills have to be introduced or when the focus is directed to improving existing skills. Data that confirms clients' existing skills are enough. The focus can be on demonstrating predicted performance based on information the SLP learned from the assessment. Even when a skill can be done without assistance intermittently, there's no need to show positive change in the level or type of assistance. As long as the message can be produced without full dependence on prompting, that's enough. Of course, if there is positive change, it should be noted, even if some assistance still remains at the end of the trial. A final word, at least for now, about these show me criteria is that they have very specific focus. They're focused on functional communication, or what we would call message types, or what actually the guidelines call message types. There's no focus, however, on message content or message production. As a result, there's no focus on whether the client initiates communication or is responsive. There's no focus on whether novel messages are created, or if the messages are based on sequencing or spelling or page navigation. There's also no focus on what assistance is provided as long as it's no more than intermittent. All of these points were disputed indicators of whether proficiency or competency had been demonstrated under the existing guidelines. Let's look at some other items in the coverage criteria. One of which is that the coverage criterion 1F says that the SLP has to be experienced in AAC service delivery. This is a new provision. Medicaid copied it from the Massachusetts Medicaid SGD guidelines, as were some other provisions that we'll talk about in the course of the evening. There's no threshold level of experience that's required. There's no degree or certificate available to show, and there's no minimum amount of time or minimum number of clients that have to have been served. Instead, just view this as a reporting requirement. State the number of years of SLP experience from the year you received your certificate of clinical competence. the number of years that you have of AAC experience. And it's any form of AAC, not just SGDs. If you focus on people who need SGDs, obviously add this information. If you have prior funding requests, estimate the number, state generally the funding sources that were asked to approve the devices, such as Medicaid or insurance or Medicare, and state the outcomes, that the devices were approved. If you have prior New York Medicaid funding experience, state the years of it, the estimated number of clients you've served, and the outcomes, again, with the expectation that the devices were approved. If you presented at conferences, if you teach, if you've contributed to professional literature, obviously identify anything that's relevant in those categories. And if, as you like spending your summer evenings listening to me drone on, and you get your CEUs from AAC-related content, report that as well. Or it's possible that this will be your very first case. And my recommendation here is to ask the supplier of the recommended device or another SLP that you know and who's nearby to serve as a collaborator with you on this case, just to get past the first one. The general conclusion is that no one should be deterred by this provision, especially because it's not clear that Medicaid's SLP reviewer has any SGD experience herself. The next item in the coverage criteria relate to eye gaze. These are new guidelines. They introduce specific coverage criteria for this particular accessory, but there's little about it that really warrants mention, which in a way is good. For eye gaze only, an OT or a PT must be part of the assessment process. Their focus will be on positioning, access, and alternatives, and that's part of the introductory paragraph for coverage criterion 2, as well as coverage criterion 2G, as in good. For all other forms of access and for all other requests in general, an OT or a PT may participate, but is not required to do so. The criteria focus on two things: ruling out alternatives and on the client's ability to use the accessory. And this is an outgrowth of the lawsuit that the guidelines are the result of, because eye gaze was the disputed factor in with regard to the Medicaid recipients who brought the case. In terms of ruling out alternatives, it's referenced in the introductory paragraph as well as in 4 of the coverage criteria, subparagraphs A, E, F, and G. The introduction says eye gaze must be considered last, but that's not meaningful. Eye gaze has to be considered as the least costly, equally effective option, and that's the test. Obviously, you can do, you can conduct an assessment in any order you want, but at the end of the day, eye gaze has to be the least costly option. So that makes it last, not the idea that it has to be considered last. The new guidelines identify 5 alternative options that have to be considered. Scanning and head pointing, both are mentioned in coverage criteria 2A, and they say that multiple attempts have to be shown, and I'll get to that in a minute. You also have to consider other forms of eye gaze from other manufacturers. That's 2E. You also, at the other extreme, have to consider boards or E-Tran systems. That's 2F. And the catch-all of all potentially less costly methods, including boards, mentioning boards twice. So Medicaid mentions boards and E-Tran, so will we. They can be ruled out categorically for all clients. They're not an appropriate option for anybody. The answer is exactly what was told or what played out in the courtroom in the case that led to the guidelines being rewritten. There's no one responsible to hold the boards, and there's no one responsible to hold the E-Tran frame. Medicaid tried to claim in the court challenge that, oh, the client can use boards or the client can use E-Tran. The problem is the client doesn't hold the boards and the client doesn't hold the E-Tran. Someone else has to, and no one else is responsible to do so. For this to be a reliable or viable option, there has to be someone to be paid to serve in that role, and we called it a communication assistant. But when asked if Medicaid would do so, pay for a communication assistant, a Medicaid witness said, "We don't hire anybody for anything." And the citation to that is written below on the guideline on the slide. For this reason, boards and E-Tran can't be considered appropriate alternatives. Also, if Medicaid actually agreed to pay for a communication assistant, the cost would make this option more costly than an SGD and eye gaze accessory after only about 4 months. And doing the math is a very interesting thing, because you'd be having an assistant with you pretty much for your full waking day. And let's say that's 14 hours. That person gets paid by the hour, let's say $10, which is actually less than the New York minimum wage. That 14 or 12 or 14 times 7 is 98 hours per week, times $10 is about $1,000 a week. After just 4 months, it's $16,000 for this solution, and that's probably more than Medicaid pays for an SGD and an eye gaze accessory. So this can be foreclosed, but you have to explain this. You can't just say, "Oh, this doesn't work, this is ruled out because." You have to go into detail with Medicaid. Medicaid recognizes that scanning and head pointing are more likely to be possibly appropriate. So the new guidelines want multiple attempts, but multi-day evaluations are not required. The suggestion is to try head control as an option at several times during the assessment and just document the client's abilities or not with each repetition. The new guidelines require that you consider more than one eye gaze accessories, the others being from another company. But a trial of this second eye gaze is not required. It can be ruled out on the basis of client performance, client preference, cost, or any other factor that warrants ruling it out. Although the time available tonight requires me to skim over ruling out switch options, here that's where Medicaid is going to offer you pushback in the form of missing information letters or outright denials. Documentation about this is the key. Also note that Medicaid may say another option should be trialed, but this is not required. Only one trial is required, and it's the trial of the recommended device and the recommended access method. Multi-device trials were once proposed when the guidelines were being drafted, but they were dropped from the guidelines as they appear in their final form. Finally, turning to Medicaid's interest in the client's ability to use eye gaze access, the new guidelines copy the show me requirement of using the eye gaze without being fully dependent. And that is how we address that is what we said earlier about finding things that the client can produce as functional communication on his or her own without assistance, which would include without assistance using the eye gaze, or using the eye gaze with intermittent assistance. Medicaid also says that functional use doesn't include simple eye tracking activities or learning tools. That's coverage criteria 2B as in boy. And they want to know the client's ability to calibrate the device or obstacles to calibration. But that's stated elsewhere, and that also is stated elsewhere in the guidelines as a documentation requirement on page 110. This is appropriately described as just a documentation or reporting requirement. The client has to be able to calibrate the device to produce any functional communication without being totally dependent on assistance. So this is another data for data's sake, and the need to report as is the need to report the client's endurance to maintain eye gaze. The client has to use it functionally. I'm not sure what the client's endurance level matters in that regard, as long as they can do it. Let's move forward. Mounts are addressed as the third item for which there's coverage criteria, and it's listed at page 107. The new guidelines add to the discussion of mount coverage that a client can get one mount that meets the client's needs in all customary environments. I was told that this was Medicaid's practice for many years, but never before had there been a number stated in the guidelines. It's possible that a client is in multiple seating and positioning settings throughout the day, and a wheelchair mount won't be able to be adjusted to allow SGD access throughout the day. If that client is a child, the one-person limit can't be applied. Federal Medicaid law prohibits limits on the amount of medically necessary care that's offered to a child. If the client is an adult, consider 2 mounts or a Tobii Dynavox universal mount to meet all daily needs. Medicaid law prohibits programs from claiming that we will meet all needs in a particular area, but then apply a limit that keeps some clients from meeting all their needs. So an example from that is actually a court case which said, we'll cover all dental needs. This is Indiana Medicaid speaking. But the annual cap for dental care is $1,000. It turns out that a client needed a single procedure that cost more than $1,000, and she wasn't able to get it. She went to court and the cap was thrown out. So you can just disregard the substance of this particular provision, that only one mount can be requested. But if you do conclude that one will not be enough, you have to be very clear about why that was why that conclusion was reached. The next thing in the guidelines are non-coverage criteria, and I don't have a slide for this because I really don't want to point anything out to you at this time about them. The non-coverage criteria is another example of text copied from Massachusetts. In my opinion, Medicaid needn't have bothered because none of these is likely ever to be the basis for denial of an SGD request. Instead, the non-coverage criteria can be valuable to support SLP recommendations. So, for example, one provision, item number 1, has a curious phrase. The client lacks the ability to learn to use the device at any subsequent time. Now, Medicaid is asked to purchase the SGD after the trial and based on the client's ability to produce functional communication without being totally dependent. If Medicaid accepts this, the device is delivered, and once it's delivered, the device becomes the client's property. There's no subsequent time for Medicaid to review, that Medicaid will review the client's use or anything that can result in the device being taken away. So this is just an empty statement. The phrase ability to use the device, also found in coverage criterion number 1, is valuable because that phrase can contradict any Medicaid claim that the client must be able to do more than the minimum required to comply with the coverage guidelines. Also very helpful are non-coverage criteria 4, 5, 6, and 7, which I'll discuss later. This is the introduction to the section of the guidelines that Medicaid calls documentation requirements. And I'm going to take a short step here to focus on what I'll call a warning. Medicaid stated coverage criteria that require specific data to be collected and then reported. We discussed this in the context of show me criteria. This section of the guideline discusses the assessment and trial procedures. This section is notable because Medicaid doesn't refer to the show me criteria here. Instead, the introduction says that in addition to following the requirements of this section, don't forget the coverage criteria. I don't view that as very helpful, but that was what Medicaid and we agreed to. In terms of the documentation requirements, the first of them uses a phrase that sent me to the web link that's here. I had no idea what a fiscal order was. Basically, a fiscal order is a form that is where the physician's prescription is written. The next one in sequence is the Medicaid requirement or demand that for recipients who are attending school, that the current IEP be submitted along with the funding request. This is another new addition to the guidelines. Previously, Medicaid rarely asked for IEPs, and even when they were asked for, they weren't always provided. There are many reasons an IEP should not be submitted, and Medicaid, in the course of developing the guidelines, never actually said why it needed or wanted them. But now that it's a requirement, if it's omitted from a packet, expect the Medicaid to give you a missing information letter specifically to submit it. And if that request is not honored, expect the request, if that request for the IEP is not honored, expect the SGD request to be denied. So my advice with regard to IEPs is to submit them, but to do something else as well. You have to review the document, and my recommendation is that you should review it after the trial, basically when you know as much as you are going to know about the client at the point at which you're about to send in the funding request and to prepare your report. Look at the attendees at the IEP meeting, which is called the CSE meeting in New York. And one of the things you should look for was, what is the SLP for the student present? And at the end of the document, there may be signatures, or there may just be attendees. Who was there? Was there an SLP report attached to the IEP? And that will be unlikely. There may be an SLP or a speech pathology section in the IEP, but it's unlikely that an independent SLP report will be attached. Then look at the content. Are there facts reported that are consistent with the facts that you found in the evaluation and in the trial? And my recommendation is to highlight those that are different. The same thing would apply to opinions. Are there opinions or conclusions stated in the IEP that are in conflict or just different with the SLP recommendation? Highlight those as well. And to the extent that there are conflicts or inconsistencies that are in the IEP and that you think might be a problem if Medicaid had the opportunity to review the IEP without any attempt to provide context, I recommend that the family or the client and you work together to take 3 actions. First, request an IEP meeting of the school to address the differences or conflicts that you've identified, and suggest at the meeting that the school leave out all opinions and say instead that the school staff is waiting for the Medicaid paid device to be approved, and then goals and a plan will be written for the student using the device. To do so is in the school's financial interest, because if the Medicaid device is denied, the school may have to pay for the device. A second recommendation is for the family to submit a request under a statute known as FERPA, F-E-R-P-A. It's the Family Educational Rights and Privacy Act. And it provides a right for families to have corrections made to incorrect, incomplete, or potentially misleading content in the student's records, one of which is the IEP. You have to make this request in writing and point to the SGD or speech point to the information that's not consistent, and ask that that be corrected based on the SLP's report and recommendation. And the third thing that you can talk to the school about is to request a due process appeal based on the content of the IEP. Once those things are done, there may be 3 documents that you have, 3 one-page letters. Make sure the meeting request, the FERPA appeal, and the due process appeal letter are stapled as cover letters or cover documents to the IEP. The goal here is to make the IEP unusable by Medicaid. That Medicaid will be unable to say that the content of the IEP is credible and that it can't possibly be relied on if the same content has been identified as flawed and subject to these active review procedures that are all channeled through the program that led to the IEP being created in the first place. Those are special ed correctives, IEP meetings, FERPA, and due process hearings, all focus on the relationship of the kid in the school environment. And the parent is exercising their authority to say, this is wrong and I want it fixed. And Medicaid can't, in good conscience, then rely on the IEP to say the IEP is credible when it's in the process of being challenged. Medicaid wants an IEP and it gets one. But we've said that it has no role in the Medicaid request, and we're able to take these steps to make sure that it can't be used, certainly can't be used to harm the client. Another thing that is in the documentation requirements that's new is testing. The documentation requirement 4D on page 109 says that psychometric or developmental assessment is required unless the client has no evidence of cognitive functioning deficits. This also is copied from Massachusetts, and Medicaid added this provision even though it's generally accepted that there exists no formal tests that predict the ability to use any specific AAC device or system. And that's from the very first edition of Buchelman and Miranda. And in the 27 years to the present, there's no reason for that conclusion to change. And in the most recent edition, the fourth, from 2013, they said that it's important to realize that thousands of successful AAC interventions have been initiated without formal documentation of cognitive abilities. And that's at page 158 of the fourth edition. The first draft of the guidelines, in the first draft, Medicaid named several tests. But these examples were deleted by Medicaid, leaving SLPs with really no information as to what tests will be acceptable. Before we get to suggestions of tests, I want to make clear that there's no requirement here for formal tests or standardized tests. Neither of those terms are in this provision. There should be no assumption that either type of test has to be used. And even though Medicaid didn't provide examples, we think it's not appropriate to leave SLPs guessing. So the examples that follow were selected on the basis of these four criteria. And as you can see, there are only three criteria stated, but the instrument that has the characteristics of a test or protocol actually should be the first, and the others should be 2, 3, and 4. So based on this, we wanted something that looks like it can be called something that could be called a test or a protocol, something that will give you as an outcome developmental levels or abilities, something that can be performed at the minimum amount of disruption to the normal assessment procedure that you have to go through, and something that isn't going to be totally useless and just a make work assignment, but actually will provide some data that will be useful. And when we asked about this among speech pathologists through USSAAC, we came up with these four tests: the communication matrix, the PPVT, the TASP, and the TACL, as if we don't have enough acronyms in our community. There are asterisks after two of them, the matrix and the aided communication symbol preferences test, and those were among the list of tests that Medicaid originally proposed and then deleted. So we would think that those will be acceptable and you can use them. In addition, we also searched about 24 Massachusetts SGD approvals from this year. From those SLP reports, we identified 7 other tests that had been reported. The Massachusetts lists include the ones that are on this slide: the Goldman-Fristow test of articulation, the the AAC Evaluation Genie, the Receptive One-Word Picture Vocabulary Test Preschool Language Scale, the Formal Receptive Vocabulary Assessment Applied Autism Language Program Communicative Operations Framework, the AAC Profile, and the Functional Communication Profile. Also notable from our review of these Massachusetts approvals is that in almost half of them, no test was identified, yet Massachusetts Medicaid approved the device. Massachusetts may not think this is a very important requirement, but we can't really assume that Medicaid will take the same view in New York. So we recommend that you identify the test that you use, and then include the text from slide 22 that'll provide notice to Medicaid that the test can't answer the question of whether or which type or model of SGD the client needs. We also recommend that you note that at best, the test provides baseline data of the client's abilities, having received admittedly inappropriate or insufficient services to date. The point is that no matter what the test reports, it doesn't allow conclusions about how the client's abilities can change if appropriate tools, instruction, support, and opportunity to practice are offered. That's the same point we're trying to make about the IEP. Neither any of these tests nor the IEP is a credible source of information. The next part of the guidelines speaks about how the SLP goes about making decisions. And SGD and access recommendations are the product of professional judgment about what type of device and access method is appropriate for the client and which is the least costly, equally effective alternative. The same is true in New York as everywhere else. What's different now in New York is that SLP judgment must be explained in minute detail. And SLP should expect Medicaid to push back in the form of missing information letters or denials based on claims that documentation isn't complete. For example, the guidelines direct SLPs to report about and explain their decisions to rule out 1, 2, 3, 4, 5, 6, 7 different ways of communicating. Speech or writing, why is that insufficient for the client to meet daily communication needs? That's one of the coverage criteria. 1B. Other unaided or nonverbal aids, such as boards, books, and PECs. That's mentioned twice in coverage criterion 1C, as well as in one of the documentation requirements. Then they want you to talk about all prior devices that were used and devices similar to the recommended device, but from other manufacturers. And then there are 3 asterisk items with no labels. And these are notes for additional Medicaid demands that aren't found in the guidelines, but that they're going to require you to address anyway. So the first of these additional topics is something that's already being focused on by the Medicaid reviewer. And that's the need to rule out SGD software as an option, so software only, using a family-owned or client-owned device. This isn't a new topic. It's mentioned as an option in the existing guidelines. What's different is Medicaid's unrealistic expectation that this option ever will be an acceptable solution. So Medicaid can require you to ask if this is an okay way of proceeding, but Medicaid cannot require this option to be accepted. The new guidelines provide many specific reasons for clients' families to say no. This slide identifies several of these reasons. Any one of them is enough, but we recommend stating all that apply. In fact, this probably will end up as a checklist that will provide to you that you can just check off all that apply and just attach it to your report. So obviously, if the client doesn't own a tablet, this option doesn't exist. But even if the client owns a tablet, you can say that when asked, the client said no. You don't have to provide a reason, and neither does the client. Using family-owned equipment or client-owned equipment is voluntary and can be refused for any reason or for no reason at all. The client may own a tablet and the client may say no after the non-coverage criteria, especially numbers 4, 5, 6, and 7, and the repair criteria were reviewed. And here's why. Medicaid won't pay for the installation of software. Medicaid won't repair a device if it's just had software added to it, if it malfunctions. Medicaid won't replace the device if it's irreparable. Why would anyone want to put one of their devices to that use if Medicaid is saying, you know, thanks for doing this for us, but we're not going to do anything to support this device for you? Another reason would be that the device is used by other family members, so it won't be available to serve as the SGD. The client may use the tablet for recreation. It will remain open as a non-dedicated device, and these options will always be a distraction. In addition, software comes with no support, but the client may need support. And assuming that the client does, that has to be explained in the treatment plan section of the SLP report. Another factor is some software isn't even available separately for funding, such as some of the software from Tobii Dynavox. And the last is, to the extent Medicare won't repair or replace the tablet, the use of the client's tablet isn't the least costly appropriate alternative. Medicaid will pay for software now, and later when the device breaks, it's going to have to buy a new device. So that total is greater than the cost of the device alone. And the new device will also be dedicated, leaving the family with no way to access the things that the family might want to use the device for. They'll have to get a new tablet, and that won't be a less costly option for them either. In sum, Medicaid is directing speech pathologists to report on an option that's contrary to all clients' best interests. And if those consequences are explained and understood, this option never should be accepted. But you must ask, and you have to report, or Medicaid will ask for this in a missing information letter, or just deny on this basis as they already have. In terms of ruling out other devices, let's start with digitized devices. It includes both devices the client used, as well as other possible options that they never did try. To make this second task reasonable, we recommend that you try to rule out categories of devices, at least those from other codes. For example, if you're recommending a device for prior authorization, it's a device that's a touchscreen synthesized speech device from the code E2510. To get there, you have to rule out all digitized devices. So, is there something, some fact or a combination of facts that will allow you to rule out digitized devices as a category? And you can rule out the entire category on the basis of two things. One is if the client needs eye gaze, because no digitized device supports eye gaze. And the other is to the extent that the client will use letter-by-letter spelling, because no digitized speech device has a text-to-speech capacity. And letter-by-letter spelling will not be appropriate, because even if you can sequence C plus A plus T, as I say here, it'll never be cat. But it's important to differentiate or distinguish sequencing from spelling. There is a digitized device that will allow for sequencing, the Express 32, and it's made by Attainment Company. You can sequence up to 8 cells to create novel messages, so that's another non-distinction for digitized devices. But sequencing and spelling are different, and text-to-speech is required in order to make CAT into CAT. So if these two facts are documented, the entire category of digitized devices can be ruled out, and they can be ruled out categorically without considering individual models. Let's consider other opportunities here. For other clients, SLPs should focus on the client's total message capability or the client's vocabulary and the client's ability to access the device. Focusing on vocabulary first. If possible, estimate the client's total vocabulary size. Then compare that to the message limits of single-page digitized speech output devices. These are pretty much the simple devices, the Quick Talker 7, 12, 23, Big Macs, all of those from AbleNet. None of these models offer levels or pages, and if the client's estimated vocabulary exceeds the message limit on any of these or all of these devices, those are not appropriate. It's a rule that an SGD must allow the client to say whatever the client wants to say, not only some of what the client wants to say. From this review, it's possible to rule out a subcategory, but an entire subcategory of digitized devices. Vocabulary limits also can affect digitized devices that have levels. It's possible the client's vocabulary is greater than the message capacity on many of these devices. Again, this is another subcategory of digitized devices. Others may be able to be ruled out on the basis of physical access. So all digitized devices have static displays. Devices like the M3 or the Dynamo or the Springboard aren't made anymore. Those that offer multiple levels require that pages be changed by hand. Many also require a knob on the device to be adjusted manually to reflect whatever the changed level is. There's an exception. The AMD Smart series don't require this second change the knob step. The question for SLPs is how will the pages be changed? A device with a display of 16 words and 4 levels can offer 64 messages. But if pages can't be changed, it doesn't matter if the device can offer 64 messages or 6,400. The client can only use 16. So let's ask whether the client can change the pages. That's very unlikely. The steps required to change pages is the client has to reach for the extra pages, review and sort them for the next message, extract the existing page and insert the new one, reset the level knob on the device to match the new page, and then store the extra pages. Whether due to cognitive or motor impairments or both, it's unlikely clients will be able to perform this task on their own. A common statement in SLP report templates is that navigating through pages of language slows down or completely stops the communication process. The focus inevitably shifts to managing communication systems at the cost of independently communicating preferences, wants, and medical needs. This is stated as the basis to rule out boards, but it applies to multiple page digitized devices as well. Consider page changes by the client, but with prompting or assistance. It's possible the client will be able to do this with help, just as the client may need help to navigate pages on a touchscreen device. If so, compare what's needed on the two devices. The actual tasks are far simpler on a touchscreen device. Changing pages requires the same physical action as is needed to produce speech. You're just touching a different cell on the display. But can page changes be performed without assistance on the touchscreen device? If they require help, what's the nature and the frequency of the help as compared to the assistance needed on the digitized device? In either circumstance, independently or with help, which procedure takes more time? In either circumstance, which results in more errors, fatigue, communication breakdowns, or lost communication opportunities? As noted on this slide, assistance is not appropriate compared to independence. More help is not appropriate compared to less help that's needed. More time is not appropriate compared to less time. More adverse effects are not appropriate compared to fewer. Reporting these comparisons can support ruling out multi-page digitized devices. The final consideration would be if page changes must be done by the communication partner, and basically that they can't be done by the client. If that's so, multi-page digitized devices can be ruled out categorically because for the same reason as boards can be ruled out, there's no duty for the partner to perform this role, and as we've already discussed, Medicaid won't provide a communication assistant. And also true is that even if Medicaid paid for one, This would become an ever more costly solution after only a few months. Overall, the goal here is to provide a reporting strategy that allows SLPs to categorically rule out digitized speech output devices on the basis of the easy-to-understand principle of access to all messages. Digitized devices can be reported not appropriate because either their total message capacity or their accessible message capacity is inadequate for this client. Let's move on to ruling out other touchscreen devices. Medicaid also directs speech pathologists. I'm looking at to the time. Okay. Medicaid also expects speech pathologists to report that they considered other devices that function similarly to the one being recommended. This has to include devices from at least one other manufacturer. The guidelines say so explicitly. However, Medicaid will most likely demand consideration of more. They'll want all less costly E2510 devices, touchscreen devices, to be ruled out and for that ruling out to be explained. This code has lots of devices and a wide range of prices, and distinctions are going to be needed to rule out the less costly options from the same manufacturer as the recommended device, as well as other less costly devices from other manufacturers. It may be necessary for SGD sources, the manufacturers and the suppliers, to produce resources for you to make these distinctions more clear. Let's move on to the trial, although we're really circling back to the trial. As in the current guidelines, which date back to at least 2012, an SGD trial period is required. It's stated in the documentation requirements 4G, and there the guidelines list 11 subparts. Despite the number of these sections, as we've already discussed, the list is incomplete. The specific requirements of the Show Me list, stated in the coverage criteria, also have to be gathered in the trial. We've discussed that the key factor in the trial is the concept of functional communication. Devices are to be used for communication, so Medicaid wants proof that's how they'll be used. Functional communication is mentioned at least 4 times in the discussion of the trial. We previously stated that SLPs should equate functional communication with reasons for communication or message types. Through the assessment, SLPs should identify 3 to 5 strengths the client can demonstrate, and that will be the focus of the trial goals. That's item 2. And also will answer items 7 and 10. So some of these 11 are addressed by the same information. These will be message types the client can do on his or her own without assistance on a consistent basis or without assistance on an intermittent basis. These will be reported on the client's baseline functioning, which is item 3. I'm repeating information to emphasize its importance. The trial discussion is the key to device approval. The coverage criterion 1G says as much. The member has demonstrated the ability to use the SGD as evidenced by a data-driven trial. I also restate that the trial goals should be based on what you know from the assessment that the client can do. It'll confirm this and provide actual use data to confirm it. By contrast, trials should not be the time to present and test new abilities or new skills or demand that existing skills improve. Improvement may occur, but this will be a windfall. It should not be a required outcome. Also, make sure you state clearly that any vocabulary or messages that you use in the trial are not necessarily all the client knows or can say. Instead, say you sampled some of the words solely for the purposes of giving the client meaningful communication to produce during the trial. The overarching goal of the trial is to show, with data, the 6 things Medicaid's looking for. Functional communication of multiple message types, without full dependence on help, with multiple people in multiple places and over the course of multiple times. More can be said in a trial. You can certainly add more things to it, but it doesn't have to be. and it probably will be dangerous to do so because you're inviting Medicaid to find more things to nitpick. In context, you've already made a preliminary or primary conclusion about the device type and the device model and about the access method. The trial is a way to back up that decision with data. You have a great deal of control over what the trial focuses on, as well as how it will be conducted. Your only constraint is to be sure to meet Medicaid's demands for the show me data. Consider the trial as an advocacy task, because that's how it's going to be reviewed by Medicaid. Here are some miscellaneous points about the trial. Item 4 of the trial elements asks for information about where the trial occurred. Remember, a one-site trial is perfectly fine, but coverage criterion 1D requires data from multiple places at that site. Item 5 asks about structured or unstructured settings, but the guidelines don't say what these things are or what they mean. My suggestion is not to guess and not to assume. Say instead that these terms are not defined and they're not mentioned in the coverage criteria. And you can say further that the actual settings for the trial are reported. That should be enough. Items 8 and 9 refer to records you have to keep about how messages were constructed and what the messages said. If sequencing, Medicaid's reviewer wants each selection to be separated by a plus sign. But note the guidelines don't require sequencing, spelling, or novel messages. Medicaid can question why someone relying on a single hit message can't use a digitized device, but this is a least costly issue. So you should refer to your review of digitized devices to show why they're not appropriate. Message samples are discussed in item 8. To satisfy this element, don't follow the rule of 3 to 5 that we mentioned for the other points of the show me data. Medicaid will likely ask you for more. Instead, offer about 7 to 10 examples based on the several message types that the client's going to produce or has produced. Item 8 also asks about the assistance the client needed during the trial. But remember, assistance is allowed. Just reporting it is not a problem. These are documentation requirements is what you did. It's not a coverage criteria. Clients just can't be totally dependent on help, but they can get some help of any kind, as long as it's only sometimes or intermittent. You also may want to state that the type and amount of help needed reflects the limited time to date that the client has had access to the device, more than as a measure of the client's abilities after instruction, support, and time to practice will be provided to the client. The next thing to see in the guidelines, or to review in the guidelines, is the implementation or treatment plan. It's discussed in the documentation requirements at paragraph 4H on page 110. This is a carryover from existing guidelines, and it's quite common for other funding programs as well. Often it's viewed as a burden without benefit because it describes post-approval, post-delivery actions. I encourage you to think differently about this task. I want you to use the description of future needs to reinforce the device recommendation, specifically to assess whether the client will need and benefit from the scope of post-delivery services that some SGD sources will provide and others won't. A software only, for example, may come with no support, but if the client will benefit from access to a local representative, training for the client, the family, and other partners, the client will give up a lot by buying software only, or by downloading a software app onto a tablet that'll be sold together. The plan doesn't have to be long, but it should be used strategically to support the device recommendation in any way you can think of. Another item that we've discussed already is repair. We did so in the context of the use of family-owned devices. Repair only will be performed on devices that meet the minimum coverage criteria for SGDs, and the guidelines in the introductory paragraphs, even before the standard is stating, says that Medicaid will only pay for dedicated devices. So the repair provision, as well as the non-coverage criteria number 6, say the same thing about minimum coverage criteria, family-owned tablets don't meet this test. Non-coverage criteria number 7 says no reimbursement will be provided for repair of a non-dedicated device. There may be other repair issues in the future, but we'll have to see whether Medicaid uses the repair provision to create barriers. And to the extent that they arise, as they say at Wait, Don't Tell Me, we'll tell you about them. So I've reached a point where I'd like to offer some concluding comments. And if we have a few minutes, we can take a few questions. So tonight's presentation was intended just as an overview. And I've offered some suggestions in addition. A more in-depth review is just going to have to await the start of implementation. Medicaid may begin to apply these guidelines very strictly, using them as a club to delay approvals needlessly or to issue baseless denials. If there were long missing information letters, for example, or requests for information already reported, or multiple missing information requests, SLPs need to answer them. If information requests are repetitive, say the information already was submitted and cut and paste the same information into the next response. But please, don't refuse to reply and don't express anger or frustration to Medicaid. Neither of them will help the client. The one Medicaid response that you do not have to follow is a call for additional trials. There's no multiple trial duty in the guidelines for devices or for access. To consider more than the items that you've already considered, yes. To do a trial of something else, no. Alternately, if Medicaid interprets these guidelines reasonably, there's nothing in these guidelines to prevent clients from gaining access to any type of device or any type of access method. As a final comment, there will be another webinar to review the new guidelines. It'll be held on August 15th at 10 a.m. and it'll be sponsored by Medicaid. Registration information is stated on this slide, and I encourage everyone to participate. My guess is that the information that Medicaid offers won't be exactly the same as mine. If you have questions after tonight's presentation or after the Medicaid webinar, you can contact me by phone or by email. My contact information is on the first slide. Another source of help will be the staff of the SGD manufacturers and suppliers. So I have 21 minutes after, so I'm going to say thanks for listening, and I apologize for the trouble we had at the beginning. We do have some time to take a few questions, and I'll be happy to answer them. Amy, if you can forward them to me orally, that will probably be the most efficient way. So again,
Sure.
Thank you all.
This was awesome, and just my reaction is, wow, the burdens have really increased on the report writer and the SLP. Anyway, yes. We do have a few questions. One was about the SLP's level of expertise. Should that be included within the evaluation report or a separate attachment? And is all of that still needed if the SLP has the ATP certification?
So first, whether it's in a separate document or in the assessment is a matter of that can be resolved at the convenience of the SLP. The information should be submitted. It establishes that you meet this particular requirement, but how or where you present it is your choice. I don't believe that the ATP is an AAC experience criterion. If you have it, cite it. But again, we don't know that Medicaid is going to ever use that as a reason for pushback or denial. So for those SLPs who have it, cite it. For those who don't worry about it.
Thanks. So obviously tonight's webinar was in response to changes to New York Medicaid. In your crystal ball, what is the likelihood that other states may begin to impose similarly restricted criteria?
So my hope, at least, is that no one does, because a lot of the things that are here reflect a breakdown in what I'll call the level of trust between Medicaid and the professional community in the state. Whether that's justified or not, people's opinion can differ. But after all the time that we've had this community and all the effort that we've made to establish that speech pathologists are professionals who know what they're doing, who have no financial stake in the outcome of the request, who are doing it in order to provide assistance to people who are basically needlessly disabled by being unable to express themselves because a tool is readily available to enable them to improve their communication. The idea that we've taken a step backwards to make things harder now is very disappointing. And I would hope that in other states that we'd be moving in the opposite direction.
Great, thank you. There was another question regarding the need for an OT or PT with eye gaze devices. Mm-hmm. So she doesn't really elaborate about her question per se. But there was another question or comment about whether calibration information is really necessary.
So one of the things that was in my presentation is that some of the things that Medicaid asks for, and an eye gaze calibration is an example, if you have a burden to establish you can provide functional communication without being fully dependent on assistance, how can you accomplish that without getting past the calibration stage? And it shouldn't require anything more than saying that it's quite obvious that the person can calibrate, and we watch the person go through the calibration task in order to get to the functional communication opportunity, which they did also. I don't know what you have to explain other than this is how the client went through the calibration procedure, and then move on to the next topic. Because again, if you're going to be submitting a request with any expectation of approval, you have to have demonstrated far more than what calibration requires.
Okay, another question came in about clients who are longtime users of SGDs, but they need a new device because their current device is unrepairable. Does a formal trial need to occur and this whole process again?
So I'll say that that's one of the points that it appears the guidelines are silent on. I mean, if there was some reference to it, it would be in the repair section. And I'm going to just turn to it now while I'm trying to answer it. They talk about upgrades, but we're not talking about an upgrade. We're talking about a replacement. So it says when repair is required due to trauma, you have to have reasonable measures will be taken to prevent a recurrence. The decision whether to replace a device will be based on which is the most cost effective. So if the device is irreparable, that presents it's got to be replaced. And then the question is, the minimum coverage criteria have to be met. And that raises a question that I don't have the time this evening to go through. But the minimum coverage criteria, I would argue, is the improvement standard, not the documentation portion of it, even though documentation is part of the coverage criteria. It all becomes circular.
Yeah.
I would hope that you wouldn't have to, if you want to replace with simply the newer version of the device that no longer functions and can't be fixed, you should be able to get it as long as your condition has remained the same, that you would have that much of an evaluation, that the device remains medically necessary for you, that you continue to use and benefit from it, and that's why you want it replaced. On the other hand, saying you have to go through the full-bore evaluation process and documentation process and trial, I think that that is overkill for what you're talking about.
Okay. So there was another question about an instance where the evaluation and the trial period may be conducted by two separate SLPs. So what would that wrinkle imply in terms of reporting or requesting?
Just as we want the client to be able to communicate with others, I would say that that's a circumstance where the two SLPs have to talk to each other.
Okay.
I mean, I don't think there's a requirement that either one must be the one who submits the report. Okay. But working together, the report has to be written, and it has to include the elements that each of them observed and the professional judgments that each of them lent to this client.
Okay, so even though there's two clinicians involved, it can be submitted as one request with the.
Oh, of course. If you think about people in school districts, there's often an assistive technology coordinator that may have multiple building responsibilities or district-wide responsibilities, and a PT as well as an SLP in a building that may be able to direct attention to this client's needs. There could be 3, 4, 5 people involved in the evaluation and can sign off. Medicaid would probably think that would be better to have more people than just one. But if you're saying that each one is responsible for a distinct part of the evaluation, that can become problematic because they have to talk to one another to make sure that the information from one gets carried over into the other.
Great. And there are more questions, but let's wrap up with this one. For testing, some of the tests on your list have not been normed on individuals with disabilities. So should SLPs still report the client's standardized results?
So to the extent that a test is non-standardized, that's not a requirement of the guidelines. And it's impossible to tell what Medicaid plans to do with whatever the data is. So, you know, whatever data is reported, are reported. So the idea that you have information that is not normed or can't be normed, I don't think makes any difference. I think you should say it, but just present it, because basically you're just fulfilling a documentation requirement. Let me say one more thing about any questions that remain. Amy, if you'll forward them to me, I'll answer in writing to whoever sent them. And if there's a way to make them available, you know, on a listserv or at a website, I'll be happy to post them so everybody who's participating can read the answers.
Yeah, we can work to either maybe even post it on a document that gets associated with the recorded webinar. So I'll work with Franklin on that.
Okay.
So Franklin, do you want to bring us on home? And thanks, folks, for sticking with us.
Well, speaking about Franklin, what an intro that was. Thank you very much, Lou, for the significant amount of time, energy, and effort that went into preparing and giving this this webinar this evening. The fact that so many people stuck with for the full 90 minutes, I think, is a tribute to your depth of knowledge and level of interest that people have in this topic. So thank you very much. Amy, thank you very much for your wonderful facilitation work. And of course, thanks to everyone else at USSAAC, Stephanie Meehan and Wendy Kwa and the entire USSAAC team for all the work that you guys do on the webinars. Just wanted to round out by letting everyone know that the call for papers for Conference 2020 is currently open. Papers are being submitted, so that's great news. And the call for papers is scheduled to remain open through till September 30th. So please check the ASHA website, and if you have interest, and we hope that lots of you do, please do submit a proposal. The ASHA Executive Board was holding meetings last month in Cancun, and I can let everyone know that all of our friends in Mexico are looking forward to hosting the conference next year and learning more about the field of AAC, because it's something that it's knowledge that is not widely known in Mexico. So there's a significant amount of interest. So thank you again, everyone, for being here tonight. And just to prove that it is in Cancun, there's the Spanish language version of our Hold the Date card. So again, Lou, thank you. Amy, thank you. And thanks to everyone for joining us, and have a great evening, everyone. Take care.